Hi guys, today's video is how to keep your son-in-law or your daughter-in-law out of your estate. Welcome to 2-Minute Tuesday, where I attempt to discuss an estate planning topic in 2 minutes or less. But before we get started, if you are liking these videos every Tuesday, can you please do me a huge favor and hit the subscribe button in the right-hand corner below, and also click on the bell so you'll get alerts every time we put out a new video. You might be surprised to hear that probably one of the top 5 questions we get when people come into our office is, how do I keep my son-in-law and my daughter-in-law out of my estate? It's not necessarily because my clients do not like their son-in-law or their daughter-in-law, which is entirely possible. It could be just that they're afraid that once they get a lump sum of money that you have worked your entire life to accumulate, that they are going to blow it on something frivolous as soon as they receive it. But I think one of the main reasons that people want to keep their son-in-law or their daughter-in-law out of their estate plan is because, 1, they want to protect their children, and 2, they want to protect their grandchildren. Now, some clients have said, as long as my son or my daughter keeps their inheritance completely separate from their spouse, then it should remain separate property. And the key word there is should. But there is so many different scenarios where that money can be commingled and unfortunately make it part of the marital estate. So how do we fix this problem? Well, there's a few ways. One of them we just talked about, and that is making sure that your son or daughter is completely steadfast in making certain that their inheritance is always kept 100% separate from their spouse. But you always run the risk of that money getting commingled. So you need to plan carefully when you decide to go that route. Another way to do this is to create a revocable living trust in which you name a third party to be the trustee after you pass away, and then you can still name your son or daughter as the beneficiary, but maybe they only get a little bit of money every so often so that the spouse does not have access to all of the money. And then if your son or daughter passes away, the remaining balance of their inheritance goes to your grandkids. That also brings up another way to work around the problem, and that is to, again, name a third party as the trustee and name your son or daughter as a beneficiary, but they only get the income from the trust during their lifetime. And then when they pass away, your grandkids receive the remaining assets in the trust, which I think is the goal of most people once they have grandchildren. Well, that's all for today. If you like this video, can you please do me a huge favor and click on the like button below? I would really appreciate it. And if you have any other questions, then please check out some of our other videos here on our channel, or click on the link below where you can download our deficiency checkup guide that'll give you an idea of exactly where you are in your estate plan. To continue to receive our videos, and please hit the subscribe button below or click on my face, which should be appearing right up here about now in the circle. And if you have any questions, then please just give us a call. Until next time, we'll see you later. Thanks again. We really appreciate it.